You know that moment when someone runs a red light? Not once, not twice, but over and over again, and when the police finally show up, they don't argue about the driving. They argue about whether the officer even had the authority to stop the car. That's where we are right now. So let me ask you a very simple question. If the case disappears, but the behavior doesn't, what exactly was just proven? This is not a normal political story. This is not a routine legal dispute. This is not just another headline about Donald Trump. This is a collision between the courts, Congress, and the Constitution itself, playing out in real time. And it starts with a single decision. Judge Eileen Cannon, a federal judge, dismisses the classified documents case against Donald Trump. Not because the evidence collapsed, not because the facts changed, but because, in her view, the special counsel, Jack Smith, may not have had the constitutional authority to bring the case at all. Let's slow that down. Over 30 criminal charges related to mishandling classified documents after the presidency wiped off the board in one move. And the reasoning isn't about innocence. It's about power. Who has it, who doesn't, and who gets to decide? Now here's where it gets uncomfortable. Because what Judge Eileen Cannon is really asking is not, did Donald Trump break the law? She's asking something much more dangerous. Was the system even allowed to ask that question? That's not a defense. That's a structural challenge. And while that legal argument is unfolding in a courtroom, something else is happening outside of it. Within 24 hours, 47 members of Congress sign a letter calling for Donald Trump to resign. Not a rumor, not anonymous sources. Names, signatures, public record. And here's the part most people skip over. 16 of those signatures are Republicans. Think about that. This is not opposition party theater. This is members of the president's own party stepping forward and saying, he should step down. No hedging, no quiet dissent behind closed doors. A public break. And then, as if the pressure wasn't already building, Senator Ed Markey takes it further. He doesn't call for hearings. He doesn't call for investigations. He calls for immediate removal from office. And he ties it to one claim. A military action involving Iran, conducted without congressional authorization. No declaration of war. No authorization for use of military force. Just action, first, notification, later. Now stop and look at the pattern. A judge says the prosecution may not be valid. Lawmakers say the presidency may not be legitimate. A senator says the use of military power may not be constitutional. 3 different arenas. Same underlying tension, authority. Who has it? And what happens when each branch starts questioning the other? Because here's what's not being said, and this is critical. No one is clearly answering the core question. If the special counsel lacks authority, who enforces accountability? If Congress wasn't consulted, who controls war powers? If members of the president's own party are breaking ranks, what does loyalty even mean anymore? And this is where the story shifts. Because this is no longer about Donald Trump as an individual. This is about a system being stress tested from multiple directions at once. And the most dangerous part? It's not loud. It's precise, it's technical, it's buried inside legal language like appointments clause and statutory authority. But make no mistake, those technical arguments are deciding very real consequences. Because while lawyers debate authority, or authorios, decisions are still being made, actions are still unfolding, power is still being exercised. So here's the question you should be asking. Not as a voter, not as a partisan, but as someone watching the system itself. If every branch starts challenging the limits of the others, who actually enforces the limit? And this is where the story stops being abstract and starts becoming a case. Because once you move past the headlines, once you strip away the political framing, you're left with something much more uncomfortable. A sequence of actions that don't line up cleanly with the rules they're supposed to follow. So let's switch modes. Let's look at the record. The classified documents case was filed in the Southern District of Florida roughly a year ago, built by a special counsel office appointed by Attorney General Merrick Garland, specifically designed to operate independently from the Department of Justice. That independence wasn't accidental, it was the safeguard. The whole point was to remove political influence from a politically sensitive case. And yet, that same structure is now the target. Judge Eileen Cannon's ruling doesn't dispute the existence of the documents. It doesn't dispute the timeline. It doesn't dispute the allegation that records were retained after the presidency. Instead, it goes upstream. It asks whether there is any statute, any line in U.S. law that explicitly authorizes special counsel Jack Smith to prosecute this case. And if the answer is no, then everything downstream becomes questionable. That's the logic. Now here's the tension. Because if you follow that logic to its end, you're not just questioning one prosecution, you're questioning the mechanism used in multiple high-level investigations, which raises a contradiction. The system created a tool to ensure accountability, and is now being told that tool may not legally exist. So which is it? Either the system overstepped, or it failed to equip itself to act. Both outcomes point to the same problem, a gap between authority and enforcement. Now layer that with what's happening in Congress. 47 lawmakers not reacting to a court ruling, not waiting for an appeal, but acting immediately. They cite not just the documents case, but a broader pattern, obstruction concerns, war powers concerns, and a growing sense that oversight mechanisms are being bypassed. And here's where the language matters. They didn't say investigate further. They said resign. That's not a procedural step. That's a conclusion. Which means, in their view, the threshold has already been crossed. Now bring in Senator Ed Markey's argument. He anchors everything on one constitutional point. Congress declares war, the president executes it. But in this case, according to Markey, military force was used without prior authorization. Not debated, not voted on, executed first, justified later. And the legal mechanism meant to regulate that, the War Powers Resolution of 1973, was triggered after the fact, which turns a safeguard into a formality. And that's the core contradiction, because the law is supposed to restrain action before it happens, not simply document it afterward. So now you have three layers of tension stacking on top of each other. A prosecution dismissed over questions of authority, a Congress reacting as if authority has already been abused, a military action carried out in a space where authority is disputed. Each one alone is significant. Together, they create pressure, not emotional pressure, logical pressure, because the same word keeps appearing in every layer, authority. Who grants it, who interprets it, and more importantly, who enforces it when it's ignored. And here's what's still missing from all of this, a clear, direct answer. No one is standing up and saying, with precision and evidence, this is the exact boundary and this is who crossed it. Instead, what we're seeing is something more unstable. Different institutions using different interpretations to define the same line. And when that happens, the line doesn't hold, it moves, quietly. And when the line starts moving, accountability doesn't disappear all at once. It gets negotiated. That's the moment we're entering now. Because if you track the sequence carefully, this isn't random escalation. It's a pattern. A court narrows the scope of prosecution. Lawmakers expand the scope of concern. And in between those two movements, real-world consequences keep unfolding. So let's tighten the lens. The War Powers Resolution of 1973 was not designed to be symbolic. It was written after Vietnam, specifically to prevent a president from dragging the country into prolonged conflict without congressional approval. It requires consultation, it requires reporting, and most importantly, it assumes that Congress is not optional. But in the scenario being described by Senator Ed Markey, those steps didn't happen in sequence. Force was used, then Congress was informed, not consulted, informed. That's not a technical distinction, that's a constitutional shift. Because when notification replaces authorization, the balance of power isn't just stretched, it's reversed. And here's where the logic tightens. If the executive branch can act first and explain later, and the judicial branch questions whether prosecution is even valid, then what exactly is left of the enforcement layer? Because laws don't enforce themselves. Processes don't defend themselves. They rely on institutions, and those institutions are now pointing at each other. The court says the prosecutor may not have authority. Congress says the president may have overstepped authority. The executive says the criticism is political. Three claims, all incompatible, and none fully resolving the others. Now add one more layer, timing. This isn't happening at the end of a presidency. This isn't a last-minute collapse. This is happening with political runway still ahead, with elections still coming, with decisions still being made in real time. Which means the stakes aren't retrospective. They're active. Every day this conflict remains unresolved, new actions are taken under the same uncertainty. New decisions with unclear boundaries. Now shift from legal theory to human impact. Because while institutions debate language, people absorb consequences. Fuel prices rise, families adjust budgets, service members deploy under orders that were never publicly authorized through Congress. And here's the uncomfortable part. Those consequences don't wait for legal clarity. They don't pause while courts debate statutory authority or while senators argue procedural thresholds. They happen anyway, which creates a moral contrast that's hard to ignore. On one side, a system debating who has the right to act. On the other, people living with the results of those actions regardless of that debate. And this is where the pressure peaks, not because of outrage, but because of inconsistency. Because the same system that demands compliance from ordinary citizens is now visibly struggling to define its own limits at the highest level. If a private citizen mishandles classified material, the process is clear. If a business violates federal law, the enforcement mechanism is immediate. But here, we're watching the system hesitate, debate itself, redefine itself in real time, and that hesitation sends a signal, not a loud one, but a precise one, that enforcement may depend on who is being enforced. Now step back and look at the full picture again. A dismissed prosecution, a divided Congress, an unauthorized military action according to its critics, each one unresolved, each one feeding into the next. And the longer that cycle continues, the harder it becomes to separate law from interpretation. Because at some point, if every rule is open to reinterpretation, then the rule isn't functioning as a rule anymore. It's functioning as an argument. And arguments don't hold systems together. They expose where systems are weakest. So the question isn't just whether lines were crossed. The question is whether those lines still exist in a form that anyone is obligated to follow. And this is where everything converges. Not in a courtroom, not in a hearing, but in a single, uncomfortable realization. The system is still operating, but no one can clearly agree on its limits. Because at this point, the facts are no longer the issue. The documents existed, the case was filed, the charges were real. And yet, the case is gone. Not disproven, not defeated. Removed on a question of authority. At the same time, lawmakers are not slowing down. They are accelerating. 47 signatures, publicly demanding resignation, a sitting senator calling for removal, not review, and behind those actions, a war that, according to its critics, was never properly authorized. So now ask yourself, what exactly is being judged here? Because the court is judging the prosecutor, Congress is judging the president, and the public is left judging the system itself. And that's the shift. This is no longer a question of guilt or innocence. It's a question of function. Does the system still function the way it claims to? Because here's the reality that no one is stating directly. When legal accountability can be stopped by questioning authority, and political accountability depends on votes that may never materialize, and constitutional accountability is debated in real time, then accountability becomes conditional. Not absent, conditional. And conditional accountability is not stable. It depends on alignment, on timing, on who is willing to act and who is willing to wait. Now bring this down from the institutional level to the level that actually matters. A family watching gas prices climb, a soldier receiving deployment orders, a voter trying to understand whether the rules they follow still apply at the top. These are not abstract consequences. These are direct outcomes of decisions made inside a system that is currently arguing with itself. And here's the moral contrast you can't ignore. The average citizen doesn't get to debate authority before facing consequences. They don't get to say, maybe the law wasn't properly authorized. They don't get to pause enforcement. But here, at the highest level, that pause exists. That debate exists. That delay exists. And the longer it continues, the more it reshapes expectations. Because people don't just watch what the system says, they watch what it does. And right now, what it's doing is sending a very specific signal. That power can outpace process. That action can precede authorization. That enforcement can stall if authority is questioned deeply enough. So this is not about one ruling. It's not about one letter. It's not about one senator. This is about a pattern where every safeguard, they say or legal, legislative, constitutional, is being tested at the same time. And none of them are delivering a final answer. So here's the question that remains, and it's not rhetorical anymore. If the law can be delayed, reinterpreted, or redirected depending on who is involved, is it still functioning as law? Or has it become something else? A framework that works until it's challenged by enough power? Because if that's the case, then the real issue isn't what Donald Trump did or didn't do. The real issue is this. What happens next time when someone else decides to test the same limits? If you think this system is holding, look again. If you think this is normal, ask yourself why it feels different. And if you believe accountability should apply equally, then this is the moment to say it out loud. Like the video if you believe the system should have clear limits. Comment below, do you think any branch is still enforcing those limits effectively? Share this with someone who still thinks this is just politics. And subscribe, because this story isn't over and the next move may define everything.